My name is Jeffrey Monaghan, and I'm the chair of the IVA Judges Forum. I'm also a judge of the Federal Circuit Court of Australia, sitting in Sydney. The Judges Forum offers an opportunity for judges from jurisdictions across the globe to meet and discuss issues that are of common and current interest to members of the judiciary. Membership of the forum is open to judges of all levels of court and seniority, whether exercising general or special jurisdiction, including part-time retired judges. It is hoped that members of the IVA who have been active in its committees and constituents, while in practice, as lawyers will find in the Judges Forum an additional means of maintaining their involvement after appointment or election to the bench. The activities of the forum are normally concentrated on the organisation of sessions at the annual conferences of the IVA. It has been the practice in recent years for those sessions to be co-sponsored with other IVA committees and constituent bodies, dealing with subjects of mutual interest such as litigation, education, ethics and the elimination of bias. The Judges Forum is pleased to be able to sponsor and present the session Open for Justice in the COVID Age, How Courts Have Responded to the Pandemic. The session is co-sponsored by our very good friends, the IBA Access to Justice and Legal Aid Committee and the Forum for Barristers and Advocates. The IBA has recognised the importance of this session by enabling it to be freely available to the public. In this session, a panel of esteemed judges will consider how courts across the globe have responded to the COVID-19 pandemic in the delivery of justice to litigants. It is my pleasure to introduce to you to my vice chairs, the Honourable Justice Ulstergan from Nigeria and the Honourable David Barneville from Ireland. Both have agreed to be panellists in this important session. Justice Ulstergan was appointed to the Federal Customary Court of Appeal in Abuja, Nigeria in 2009. Justice Ulstergan has the honour of being the first female judge of the Customary Court of Appeal. Prior to her appointment, Justice Ulstergan served in several capacities in the Federal Ministry of Justice as a State Counsel, Chief Legal Officer and Legal Advisor. Justice Barneville was appointed a Judge of the High Court of Ireland in 2017. He is currently the Judge in charge of the Commercial Division of that court. He is also designated as an arbitration judge to hear all arbitration-related matters in the High Court. In July 2018, Justice Barneville was appointed as a member of Ireland's National Group on the Permanent Court of Arbitration in The Hague. In addition to being panellists, Justice Barneville has agreed to introduce our other panellists in this session, and Justice Ulstergan has agreed to facilitate questions. I now hand over to Justice Barneville.
Thank you very much, Jeff, for your kind introduction. And it's a great pleasure for me to introduce the panelists for this session. Today, we're going to start, and I'll introduce them in the order in which they're going to speak. And we start with Chief Justice William Ulstergan, who is the Chief Justice of the Family Court of Australia and was appointed to that position in December 2018. He's also Chief Judge of the Federal Court of Australia, to which he was appointed in October 2017. And I can admit that I was actually in Sydney at the IBA annual meeting in 2017 when Chief Justice Ulstergan was appointed to that position. And he's also the administrator, and I should say I had cause to celebrate with him on that occasion. He's also the administrative head of the Appeal Division of the Family Court of Australia. He was a barrister in practice in Victoria, former chairman of the Victoria Bar, and also president of the Australian Bar Association. Following Chief Justice Ulstergan, we're going to hear from Judge Richard J. Sullivan. And Judge Sullivan is a judge on the United States Court of Appeals for the Second Circuit. And that covers, I think, Connecticut, New York, and Vermont. And Judge Sullivan was appointed to that position in October 2018. Before that, he served for 11 years as a trial judge on the United States District Court for the Southern District of New York in Manhattan. Before that, he was General Counsel and Managing Director of Marsh, Inc. And indeed, before that, he served as Assistant United States Attorney in the Southern District of New York, where he was, amongst other things, Chief of the International Narcotics Trafficking Unit and director of the New York, New Jersey Organized Crime Drug Enforcement Task Force. He was previously an attorney in private practice. He's a graduate of Yale Law School, an adjunct professor at Columbia Law School, and previously adjunct professor at Fordham Law School. Again, he's somebody whom I've got to know over the years and is, I can say, I think, very proud of his Irish roots. Judge Okezabar is going to follow and talk to us about the position in Nigeria, and Jeff has already introduced Judge Okezabar. Following that, we're going to hear from Stephen Kay, QC, who's head of chambers at 9 Bedford Row in London. He's a leading international and UK criminal lawyer who has a global reputation and has been involved in many of the landmark cases at the international courts and tribunals in The Hague, and is one of the foremost authorities on modern international criminal law. He has an extensive international practice, which includes advising governments and international organizations on international legal issues. In addition to all of that, Stephen is a recorder at the Crown Court in England and serves as a part-time judge in that capacity. He's also been involved in several international organizations and groups, including co-chair of the American Bar Association International Criminal Justice Standards Task Force, former co-chair of the IBA War Crimes Committee, and founder of the European Criminal Bar Association. And finally, and after Stephen, I'll say a few words if there's any time left to talk about the position in Ireland. So having introduced the speakers, it's my great pleasure now to pass the floor to Chief Justice Ulstergan. Will.
Thank you very much, David, and thank you very, very much for having me. Can I say it's been an extraordinary time since the 16th of March 2020, when we first had our first visual or hearings by Microsoft Teams. I think if you told me in our courts, so Jeff and I are on the Federal Circuit Court, I'm also on the Family Court. On the Federal Circuit Court, we've got 68 judges in 22 locations, in 14 of those in permanent locations, right around Australia. And the Family Court is again in many of those locations as well. So trying to get over 100 judges getting used to a very quick short-term digital transformation was quite extraordinary. And one of the things I found was that, first of all, the most important person on the court was no longer the Chief Justice, but the head of the IT department. We were so reliant upon resources that we'd probably hardly ever used. And it was amazing how quickly everybody was able to adapt to those, putting it in a position where, I suppose, from an age gap, the average age of a judge on our courts is probably pretty close to 60 years old. To try and, luckily they had a lot of associates with them who were able to assist them in being able to learn this new tool of video hearings. And luckily with the technology we had within 3 weeks actually our first electronic court book. So the pandemic has actually assisted us greatly for that point of view. But there was 2 things, I suppose. The first thing is, externally, we didn't quite know what to do at the start, because we're obviously having to do a lot of our hearings, obviously couldn't be in person, and I mean, none of them could be. We did have a protocol we set up by measuring the court and working out how many metres people could be away from each other and how many people you could fit in a courtroom, and we had to have those hearings of less than 2 hours, which restricted what we could do. We then went on to our first trials. Our trials we were up to about 85% capacity, I would say, by halfway through April. And we've maintained that through April and then right through. Different states of Australia, which is interesting, have obviously suffered from the pandemic in different ways. And what that's meant is that we've got different restrictions. So in some states, we can have face-to-face hearings now. In others, it's impossible. For instance, in Victoria, where I'm just talking to David before about going to the second stage of the lockdown. We're just coming out of that in Victoria. We haven't been able to have face-to-face hearings since June, and we may not start them again before Christmas. So the challenges have really been working as a team and getting all the judges to work as a team, re-educating them very quickly, and then making sure that our technology was working in such a way that we could actually make sure there were fair hearings. One of the biggest issues, of course, with this is to work out if the hearing is actually fair, and making sure the judges felt empowered not to go ahead with a hearing if they thought that someone was incapable of being able to have a hearing conducted in an appropriate way. Luckily, most of the hearings we've done haven't been a problem. There have been some where we've had to, like others, I'm sure, delay. We've had to look at what else we can do in relation to documents. Some of the profession has been fantastic in the way they've assisted us, but again, doing things like working out the protocols for electronic court books to make sure that no paper was passed up, even if there was a face-to-face hearing, was very important too. The other thing is education of staff. I'm sure, like everybody else in the other courts, obviously one of the biggest issues for us was keeping everybody safe. And I think we've had a number of scares, but I think we've only had one case in a court building. It wasn't actually of one of our judges. It was a secretary of a judge in the federal court. I think through the whole time, which is pretty remarkable, but we've been very lucky from that point of view. That's been run through the federal court, and James Alsop is our Chief Justice of the federal court. I've been working with him on a wall cabinet, and I think it's taught us three things, I think. The first is that we can have fair hearings electronically, and that they don't necessarily diminish the quality of the hearing, but you've obviously got to be aware of that. Secondly, we can use this type of technology in the future after we obviously hopefully come out of this lockdown to a stage where people can get in regional areas around Australia access to justice that they otherwise wouldn't. They don't have to wait for the judge to come to actually come to the town. And thirdly, it also enables people who are in genuine risk to be able to have hearings and not have to come to a courthouse. So it's been a very interesting time for us, but it's certainly been a huge learning experience. And I think we'll be at least 30% of our hearings will remain electronic going forward. So thank you. Is there anything further you'd like me to discuss?
Thanks very much, Will. That's a very useful introduction and description about what you've experienced in Australia since earlier this year. And I would imagine the experience is going to be similar in other jurisdictions. But what we might do is, I know NG may have some questions for you towards the end of the session. So if you wouldn't mind making yourself available for those, Will,
sure,
that would be great. So I'm going to now pass on to Judge Sullivan to tell us about his experience working in his court in New York.
Great. Well, thank you. First of all, it's nice to be here. I was expecting Miami, but this is the next best thing. I will say, listening to the Chief Justice, it seems that there are a lot of similarities, obviously, between what's going on in Australia and the U.S., and I suspect around the globe. I think, U.S., like Australia, is a big country, and so there are going to be regional differences. And then there are differences also among courts. Courts with different functions, I think, have adjusted differently depending on the nature of the work that they do. So in the U.S., like a lot of countries, we have a federal system, which means we've got 50 state courts, which do the bulk of the litigation work. And then we have a national court system, which we refer to as the federal courts, which have a much smaller docket, a limited jurisdiction docket. I'm a member of that branch. And so our experience is probably a little different than some of the state courts. There's more local variation, I think, among the different states. In terms of the courts, I'll start with the Supreme Court of the United States. They get all the press. And they have largely been not affected too much by this. I think they've moved to telephonic arguments in March and April and have continued with the new term that just started earlier this month. That's a little different. Generally they hear 70, 80 cases a year in person, all 9 justices, a very hot bench, a lot of questions, almost theatrical in some ways. Telephonic arguments, not video, telephonic arguments have diminished, I think, the theatricality a bit, and they have made it a little more formal. I think it tends to be now the case that litigants get a few minutes to speak uninterrupted, and then justices are permitted to ask questions in order. So it's a little more stilted, a little less freewheeling. But at the end of the day, I don't think it's less effective, and I don't think it has diminished the quality of argument or the nature of the process. The federal appellate courts, of which I am a member, there are 13 spread out throughout the country. We've had a very similar experience. I have to say, my court in New York, we haven't missed a single day of argument. We've moved to remote in March. We did telephonic arguments through June, and now we're doing them via Zoom, which I think the litigants prefer, and I think the judges actually prefer as well. It's not as good as being there in person, but it does allow you to see the nonverbal cues of advocates and judges. And in some ways, I think it provides some advantages because it does give you a little more opportunity for close-ups, as opposed to some of these large courtrooms, you might be far away from the speaker. We didn't miss a day. We didn't even have to adjourn a day. We extended deadlines by which briefs would be filed, but otherwise our output has not been significantly affected. Our number of oral arguments has remained the same. The opinions issued has remained the same, and the turnaround time is even faster, probably because there's fewer distractions. So we're moving very efficiently. Everybody's working remotely. I'm in a courthouse today because I can walk to the courthouse. Most of my colleagues are working remotely, but very efficiently, and it's because we have, I think, very good IT support, and that is crucial. I think the biggest adjustment has been to the trial courts, the district courts. I was on that court for 11 years, and those courts, by nature of the work that they do, have been much more effective. In the US, at least, our courts are premised on jury trials, or at least the possibility of jury trials in both civil and criminal cases. That has an impact on the way cases then proceed through the courthouse. And it also is worth remembering, in our federal system, criminal cases have to proceed via grand jury. And so that typically means 23 citizen grand jurors have to hear evidence and return indictments in any criminal case. In March and April and May, that almost slowed to a crawl. There was almost no grand juries convening. There might have been a few in this locale because New York was hit pretty hard. But certainly the number of grand juries, the number of indictments returned was drastically reduced. The number of trials was diminished to almost nothing for a 4 to 6 month period. Now things are coming back. I would say that the courts are now having live arguments, the district courts. There are some trials, not the same volume as before, but we are having trials with jurors. It takes longer to pick juries. It takes longer to seat them. The nature of the courthouse is different now, that we are spreading out jurors. Witnesses testify from a witness box that is now enclosed and has its own air filter above it. We did smoke tests to make sure that people weren't breathing on each other or sharing the same breath. Defendants and lawyers in criminal cases are at the same table but separated by a distance, so they communicate typically via phone with plexiglass separating them. Deliberations for juries now can only take place in a handful of large jury rooms that allow them to safely distance while they deliberate. These are challenges that that most people hadn't really thought about before, but they are challenges that certainly are going to continue. We're now in a second wave, or maybe it's a third wave, that is causing, I think, people also to lock down again, and it may make it more difficult again, at least in the short term, to seat juries and grand juries. But I think we've learned a lot, and we've managed to get back to business more or less. The volume is down, but I think we want to make sure that jurors and people coming to the courthouse have confidence that it's a safe place to be. And I think by and large that has been the case. Getting in and out of the courthouse, I think similar to probably other places, anybody coming in has to fill out a questionnaire indicating whether they've been exposed or exhibiting symptoms of COVID. They then get a temperature check. Negative answers to certain questions or a positive temperature reading will result in a person being sent home or barred from the courthouse. Doesn't happen often, but it does happen. We have had a few positive cases among staff in the courthouse, mostly security staff, not among judges or clerks and things like that. But nonetheless, it's something we're careful about. the way staffing has worked. Most of my clerks, unlike some courts, I have 4 clerks, which is a lot more than they would in Ireland or other countries, I think, that are represented here today. But my clerks, 2 of them are close and walk to work. 2 of them are working, completely remotely. But it's worked because we do have the technology that is generally been pretty sound. I think where this goes going forward is that I think we're going to start to see in the appellate courts fewer filings as criminal cases, as the lag kind of catches up with us. That I think is inevitable. But by and large, I think it's been an enlightening experience. I think some things will never be the same. I think that pre-trial litigation on the civil side is going to use this technology much more than was the case before. I think judges will be very reluctant to drag people from all over the country to come for short conferences. That technology existed before, but wasn't used that much. I think judges are more sensitive to it. Clients are a lot more sensitive to it. I'm certain of that. In cases with paying clients, the clients, I think, are now saying, yeah, you can do this remotely. It works. We don't lose too much by you not being there. And so I think that is a conversation lawyers and clients will have going forward for the foreseeable future. No doubt about that. So I think judges are often the last people to learn technology. I remember when I started hearing that a judge's sense of technology dates back to the last day before they got sworn in. I think this has forced judges out of their comfort zones, which is a good thing. And I think it has made courts probably more 21st century than they would have been but for COVID. So that's the silver lining. And I think probably there are benefits from that. But we're all looking forward to getting back to court in person with seeing our colleagues live and seeing the advocates live. So hopefully this time next year, we'll be in Miami or someplace else warm.
Hear to that, Richard. You certainly won't find any dissenting voice coming from Ireland with that very generous invitation to travel to Miami next year, or at least travel somewhere out of the city of Dublin. Thank you very much, Richard, for that. Now we're going to move to Judge Okezobar in Nigeria to tell us about the experience that you've been having there. So my fellow co-vice chair, Judge Okezobar, is going to tell us about the experience in the Nigerian courts during the course of the pandemic. Enji.
Thank you so much, David. I also want to thank the other speakers. I think the disruptive effect of the novel coronavirus, COVID-19, the pandemic, the virus, is a cause for concern to many. In addition to the serious implications for people's health and public health care services, the COVID-19 pandemic has had some impact on the administration of justice and justice delivery in Nigeria. The Nigerian courts have been compelled to adjust judicial operations and activities, which to some extent had an impact on the provision of timely fair hearing, contributed to increase in case backlog and increased length of judicial and administrative proceedings. So following the emergence of the COVID-19 pandemic, various countries have taken different measures to curb the spread of the virus, especially with its courts and other places where cases are litigated. The Nigerian judiciary was also not left out in putting measures in place to curb the adverse effect of the pandemic on justice delivery in Nigeria. The Chief Justice of Nigeria, Honorable Dr. Justice I. Tanko Mohammed, CFR JSC, issued a circular directing the suspension of court sittings in Nigeria for an initial period of 2 weeks, effective from 24th March 2020. And then the directive was later reviewed via the letter dated 6th of April 2020, wherein the Chief Justice of Nigeria directed all heads of courts in Nigeria to suspend court sitting till further notice, with the exception of matters that are urgent, essential or time-bound according to extant laws. And in April, also, the Federal Ministry of Justice, under the leadership of the Honorable Attorney General, issued a roadmap or plan for post-COVID-19 justice system in Nigeria. The policy paper identified necessary adjustments to help reposition the Nigerian judiciary in the wake of the COVID-19 pandemic, to include deployment of ICT facilities and digital platforms in all courts, to fast-track determination of cases, setting aside special dates and that courts work extra hours to decongest their case files. On the 15th of May 2020, the National Judicial Council, via a memo signed by the Chief Justice of Nigeria, enjoined all courts to speed up trial of cases and decongest custodial centers. Some of the superior courts in Nigeria also issued practice directions to guarantee continued access to justice and expeditious disposal of cases. The Federal High Court of Nigeria issued practice directions 2020 for the COVID-19 period. The National Industrial Court on the 13th of May 2020 also issued its practice direction and guidelines for court sitting. The High Court of Lagos State issued the Lagos State Judiciary remote hearing of cases, COVID-19 pandemic period, practice direction 2. Which was issued on 15 May. And then the High Court of the Federal Capital Territory in Abuja issued a practice direction as well on the 25th of April to guarantee inter alia efficient and speedy administration of justice, and the Customary Court of Appeal, Federal Capital Territory, on the 15th of June. And the Superior Courts of Record suspended payment of default fees that accrued during lockdown imposed by the government. This has the litigation of a
I think we may have lost NG there temporarily.
Hello?
Yes.
Hello?
No, okay, you're back. Fantastic. Yes, NG.
Yes, you can hear me? Oh,
yes, perfect. Thanks.
yes, you can hear me? Oh,
yes, absolutely.
okay.
Go ahead. Thanks.
Okay, thank you very much. Sorry about that. The litigation process in Nigeria has remained adversarial. That is, parties file and submit claims to the court for adjudication and resolution of the claim. The courtroom is the traditional scene for the physical hearing of disputes, and counsel representing parties during trials are required to lead their witnesses in chief and tender documents through the witnesses in the courtroom. But with the reaction to the COVID-19 pandemic, the courts have gone into remote hearing. Some of our courts, even though prefer traditional approach of hearing matters physically, have employed ICT to hear matters remotely. Due to the pandemic, several courts have embraced the potentials embedded in ICT, and that has also helped to flatten the curve. Necessary hardware been deployed, procured to properly equip other courts that are yet to have. And we should also see the impact of the pandemic as a turning point to unlock the potential for virtual hearings in the justice delivery system in the entirety of the judiciary. Well, some notable hindrances: the Nigerian judiciary has been very proactive in responding to the outfall of the pandemic. But there are some notable hindrances. Some lawyers have often complained about the epileptic nature of the data the Wi-Fi in terms of weak signal strength during virtual hearing, which leads to disruptive hearing. The implication being that lawyers would need to probably have to subscribe to fiber optic or good network. Interestingly, some lawyers are unable to afford that facility, and even the ones that can afford it build it into the client's fees, thereby making the fees unaffordable to some. These concerns, though genuine, can ultimately be sidestepped with the introduction of some creative solutions. In our court, where the litigants cannot afford probably counsel representation and they prefer to represent themselves, parties come to court. And in our own court, what they do is they pass through, we have disinfectant disinfectant tunnel, you have to do the temperature check, and there are sanitizers, and then social distancing is also employed. And then the number of people in the courtroom is
NG, I think we may have lost you again. I see your face there now. You may be back.
Can you hear me?
Yes, absolutely. Go ahead, Angie. Yep. Thanks.
Okay. Thank you. The benefits of maximum deployment of ICT for all stakeholders will be briefly enumerated as adoption of electronic filing, which will ensure maximum security of court records. The use of electronic files will eliminate the need for large storage facilities. The ICT will help judges enhance performance and efficiency. Online database and related applications will aid legal practitioners in conducting legal research. ICT would improve staff proficiency, limit staff and litigants' interface, which would have positive effects of mitigating the spread of airborne diseases. ICT will engender transparency and
I think yes, Angie, we have you back there again. I think you're on mute again there.
I can hear you very well. Hello, can you hear me? Hello?
Yes, we can hear you now. Yes, we can hear you now, Angie. Yes, go ahead. Thanks.
Okay.
Thank you.
Okay. So the disruptive effect of the pandemic
Angie, I think it disappeared.
The disruptive effect of the pandemic. Can you hear me?
Yes, I can.
Hello?
Yes, go ahead. Thanks.
Disruptive effect of the pandemic requires the judiciary to be proactive and to think outside the box in dealing with novel issues thrown by the pandemic. And the Nigerian judiciary has reacted positively in inculcating all the necessary ICT to inculcate virtual hearing, and in circumstances where it is not physical hearing is allowed with social distancing and all the necessary COVID-19 protocols are being put in place. The efficacy of any judicial system is gauged by its capacity to provide timely and appropriate justice to parties in a dispute. the benefit. Can you hear me?
Yes, I can hear you again. You just dropped off there a second ago, but again, you're clear again. Thanks.
Thank you very much. So the Nigerian Judiciary has infused technology in reaction to the pandemic and practice directions, and that has helped a lot to also speed up the backlog of cases during the lockdown. And I would say most of the dockets are being decongested. And we're experiencing a curve that is being flattened in Nigeria. And we pray that at no distance time, it will no longer be in existence, the pandemic. Thank you so much. And
thanks. Thank you very much. Thank you very much, NG. Thank you very much for that. And now, Stephen, you have a unique perspective because you can speak both as an advocate and trial lawyer and as a judge, both at the same time. So I think you can bring a very interesting dimension to this discussion, Stephen.
Thank you very much, David, and good evening from me to all our panelists who are at different time zones for this rather remarkable achievement of the IBA that I feel privileged to be able to be a part of in getting such talented judges all together at different times but on one screen. And I note that our title is Open for Justice, but I feel it was rather closed for justice in our case. And we went into a national lockdown on the 22nd of March of this year. But the storm clouds of COVID were gathering from late January and into February. And it was not only having an effect on society, it was also having an effect on courts. We noticed that suddenly accused people were unable to attend, jurors were midway in a trial, then suddenly unable to attend. And gradually towards the end of February, the gradual seeping into society of COVID was taking its toll on our criminal courts. And long before the lockdown, courts were experiencing disruption and judges were finding it very difficult to put on jury trials. In the civil law system and the commercial courts, it was a completely different story in that there was disruption, but gradually they were able to go on to Skype for Business and carry on with their business pretty seamlessly. But the criminal courts in the UK, as with other countries that have the jury system, and I was interested to hear the experience from America, of course require a jury to remain together. They come from all different parts of a city or town. They have different roots in, they have different families, they're a cross-section of society. And they sit close together in a criminal courtroom. And they are in circumstances when they sit right next to their neighbours, fairly close to counsel, quite close to a witness box. And it was clear that as we were realizing COVID was having an effect on our society, it was quickly undermining the ability of the criminal courts to carry out their business of criminal trials. And a number of trials had to be stopped midway. Some judges limped on to finish cases, but found that their juries were reduced from 12 down to 11, 10, and then 9, the bottom number, and were fearful that if one more dropped out, they'd wasted more court time and put people at risk. So as the courts started to cease to function, it was noticeable that in our wider society, this was before lockdown, people were choosing not to come to work. They were choosing not to put themselves at risk. And they were choosing to look after their own safety long before the government decided that there was a national lockdown. And it was quite interesting how, in an unofficial way, the system started to dismantle itself and say we can't go any further. On the 22nd of March, when the national lockdown was announced, there was a long-standing trial in one of our criminal fraud courts on a big matter, and that judge had to adjourn it after 2 months of trial, not knowing when he would ever be able to resume with a jury and even with defendants. So the lockdown happened, criminal courts ceased to function, and the courts then had to consider how to get back to business when it was safe to do so. About 6 weeks after the lockdown, the large fraud trial was shifted from the court that it was held in to our central criminal court. And the practicalities of running a jury trial in COVID Britain had to be forcibly considered because no one could reassemble in the previous way that they had before. You simply couldn't put people who travelled in separately to the court with their different lives. You couldn't force them to sit next to other people. So that case had to occupy 4 courtrooms. The jury spread out in one large court, some counsel and their instructing solicitors in another courtroom, the judge with the prosecutor and lead counsel in what I'll call the main courtroom, and then the staff running exhibits and running the other administration of the court in another courtroom, all linked up by video link. But this is one case then taking 4 courts in a 22 court centre. Once that trial got underway, and thankfully there were no disruptions and it was able to reach jury verdicts, a couple of other trials had also started of matters that had to be adjourned because of the virus. And again, they had to adopt that 4-court model. There was no other way of safely holding a court hearing, as well as with the health and safety programs that were needed to clean rooms, clean buildings, clean areas where witnesses had come into court and to handle them. And so this presented a very great challenge. Meanwhile, with cases stacking up that couldn't be heard, the part-heard cases, we were getting a backlog by the time of the summer of about 10,000 trials that had been unable to take place. And so approximately a trial backlog in the UK of some 50,000 trial cases for juries, representing about half a year's total trials in our Crown courts. Other hearings had taken place through a specially developed video platform called CVP, which was introduced to judges and counsel. All our criminal cases are digitally processed anyway. There isn't any paper anymore. Exhibits, everything is dealt with on a digital platform. And the video platform was a secure platform that the courts and judges, prosecutors and counsel had confidence that would not be breached and there couldn't be security problems. So now we're entering a phase in the UK whereby courts are adjusting to having only single defendant trials. The juries still being at 12, requiring this extension of their business throughout the courtrooms. A serious problem with the backlog of cases, the impact that that is having on defendants who are in custody, and of course, the prison service and prisons are institutions that are ripe for the spread of a virus like COVID, poor ventilation, poor conditions, cleanliness problems, not least of all, how to control people. It requires often close physical contact. And as cases were tried to be got on, if there was a defendant in custody, often he was sick with COVID, and so all court preparations were halted and unable to proceed. There is a good attempt now to try and get back to business in the sense that there is a target of some 200 courtrooms around the country to be open for jury trials. I think they've reached about 160. But the problem is with the large defendant, multi-handed trials with many witnesses, and those are stacking up a big problem for the future, I feel. Looking at it also in another way, we had this problem in our history before. In the Second World War, the trial system was amended so that a jury of 7 instead of 12 could be empaneled to try a case. And that's how the criminal justice system got through the war years. A mere mention of that in 2020, in April of this year, brought out all sorts of opposition from politicians, human rights groups, and others, not familiar perhaps with the running of a court and the need for court business to be expeditiously run, and that justice delayed is justice denied. And the mere mention of it by a senior law lord bringing out that kind of reaction then closed down that potential outlet of having a 7-person jury. There's recently been discussion in reducing the figure to 9. The discussion of it being just judge-held criminal trials and no juries has not found favour with anyone as being too much of a departure from our culture and history. So we're left with the position now where there's been no debates in Parliament, no political party has wanted to raise the spectre of reducing the number of jurors, but I wonder if this pandemic continues in the way that it has, whether we can remain so resistant to what would be a temporary and expeditious change in our system to at least a reduction of jurors to 9, whether we could resist the force and necessity of having such an amendment. Originally, the criminal bar was very much against any interference with the jury system, but once the matter dragged on from weeks to months to several months, And indeed, barristers and solicitors were no longer able to get paid for their work. A number of them have not worked for 7 months because they've been unable to do their trials. There's been a little bit of a change in atmosphere on the practitioner level. So maybe when needs must, sometimes the laws can be amended, but it would take an act of Parliament to alter the Juries Act of 1986 and permit the reduction in the number of jurors. Otherwise, commercial courts are running absolutely fine. The lower magistrates' courts running absolutely fine. The big system problem is with our criminal courts and the jury system. So I hope that's a helpful summary of what it's like in the United Kingdom at the moment.
Stephen, thank you very, very much for that. And I will just speak for a couple of minutes because I appreciate our time is approaching its end. And what I wanted to say briefly, the position in Ireland, I think a lot of what Stephen has said reflects the situation, particularly with criminal cases in Ireland. I don't have a great deal of experience with those types of cases myself, and most of the cases that I hear are cases, civil cases, primarily cases of a commercial nature. But like the other jurisdictions that we heard about already, when the pandemic hit in March of last year, virtually all cases at all levels came to an immediate standstill for a period of time. We didn't have a tradition of remote hearings, and we had to learn extremely quickly before we were in a position to resume hearings of some cases remotely. We were not able to resume criminal trials, particularly those with juries, for several months after that. One major criminal trial, a murder trial involving the murder of a policeman, had started in January and did manage to proceed to completion in August, right through the worst of or what we thought then was the worst of the pandemic. As the restrictions began to lift a little bit towards the middle of the summer, we had cases, a lot of cases being dealt with on a remote basis, and we have the prospect of a return to physical trials, in-person trials, both in criminal cases and in civil cases. And some cases, some criminal trials did get back up and running at the very end of July and through August and into September. But we've now entered, as of last week, the second major lockdown in Ireland, which is pretty severe, pretty strict, and has meant that virtually no witness cases will be permitted and will be able to be run for the next 6 weeks or so. And that means that a lot of those criminal trials, except those that are at hearing, will certainly new cases will not start. Criminal cases at hearing are allowed complete. But like Stephen mentioned, for one significant criminal trial, like a murder trial, 3 courtrooms are required in order to ensure appropriate spacing for jurors, lawyers, and other participants in the case. Our court service, who I have to say have done incredible work during the course of the pandemic to try to keep work going and to try to ensure that justice is still available to people, notwithstanding the huge obstacles that are there. And they have had to source other buildings, non-courtrooms, to be available for criminal trials, such as Croke Park, which is our largest sports stadium that has a capacity of something like 80,000 spectators when spectators were able to go to sporting events. But that has been requisitioned to run criminal trials when we are allowed to have physical trials again, which, as things stand, will probably be after Christmas. I wanted to just mention a few brief points just in passing. And the first is, when cases are dealt with remotely, there is a concern about public access to justice and justice in public. And under our constitution in Ireland, justice must be administered in public. So provision has to be made for some public access to remote hearings. And that has been done by providing an entitlement of members of the media bona fide members of the media to participate by watching remote hearings, by logging in. And that's seen as satisfying the requirement that justice be administered in public. The second thing is witness cases in civil cases. Certainly in terms of the remote hearing platforms that our courts have used are not really suitable for remote hearings. We haven't been in a position to use some of the more elaborate platforms that witness cases could potentially be heard on up to now. And that may be changing. And the particular platform that we in the courts here have been using, it's called PEXIP, really is not suitable for witness hearings. And it is necessary to use other platform things so that you get the proper view of witnesses, the proper view of the parties while the witness is giving evidence. And I think it's particularly the case in cases where credibility is an issue. I think that the idea of a remote hearing is not ideal. Now that said, remote hearings have allowed us get cases on when otherwise we would not have been able to get cases on. I think there is a lot of power, a lot of strength in that argument. The next point I think concerns litigants in person. We have a lot of cases involving, on one side or the other, a litigant in person, and it was very difficult to persuade those litigants to agree to have their cases dealt with remotely. And certainly at the earlier stages of the pandemic, the view amongst the judges was that you couldn't force a litigant in person to proceed with their case remotely. Now, that may be changing now, of course, subject to being satisfied that the hearing could be conducted fairly, that there were no serious technological issues or coverage issues that might have prevented justice being properly administered. I think another point very briefly that can be made is that Another point that can briefly be made is that in some cases you can see there is less respect for the dignity of the court and court processes where the hearing is conducted remotely. If a judge, for example, is like I am, and this is in my chambers, but it's a complete blank backdrop, I don't have the garb I would normally wear. I'm not sitting in front of the harp, which is our national symbol. And sometimes it might look like you're sitting in your kitchen. And you wonder at times whether people take you as seriously as they would as if you were in court physically yourself. And some cases just do require physical production in court, either before the parties take it seriously or before they decide to talk seriously to settle their case. I think finally, I think remote hearings influence the way advocates run cases. I think the type of advocacy is very different from remote hearing. The ability of the judge to interrupt is very different. And it's a much more stilted operation, which we're all trying to get used to. It's something that we haven't been used to. I suppose we're getting better at it because we're getting more experienced at it. So they were really the comments I wanted to make, just to add to everything that everybody has said. I think the experiences in Ireland really are quite similar to the experiences that we've heard mentioned in other jurisdictions. I think now, NG, we might have time for a couple of questions.
Thank you so much, David. And I want to thank everyone for the excellent presentation on the reaction of courts, how courts have responded to the pandemic. It's been quite useful. I'll just throw in throw in a few questions. Can you hear me? A few general questions. Question one, are any of the panelists aware whether filings in their courts have increased or decreased as a result of the COVID-19 pandemic? What strategies have been adopted by the courts to assist parties that do not have access to internet facility? Has anything surprised you about the way the legal profession has responded to changes in the way the courts have been pandemic to end? Is there any other change or innovation that you would like to implement in your court, whether temporarily or permanently? Question 5, what is the one thing you miss seeing every day at work or in court during the pandemic? In throwing these 5 questions, we can react to anyone that we choose to. So we start with Honorable Justice Wills Ulstergan, and then in that order.
Thank you very much. Can I just, if I could just mention with filings, and obviously this is across the nation, we saw a decrease in filings for trials, if you like, or from final orders, but we saw a drastic increase in interim hearings or urgent hearings. They went up by something like 60 to 70% in one of the courts and over 30% in another. We also looked at one of the difficulties we had was in relation to jurisdictions where, because for the first time we had different states with borders that were being blocked, certain things couldn't be done as they would have normally been. And so it required us, and each state had a different criteria. So as a result of that, we had a lot of urgent hearings. We actually had a new list. We called it the remarkable name, the COVID-19 list. It's run by registrars. It's electronic and fully electronic. And what we do is we allow people to file a summary form of material. They can email that in, which makes it a lot easier for litigants rather than having to file it on the website or in the portal. And then they are triaged by registrars within 72 hours of it being filed. I should say 3 business days. And if it needs to go to a judge after their initial hearing of it as registrars, then it'll be assigned to either the docket judge or to one of our national judges. And I must admit, that's worked enormously well for us because we can now operate properly as a national court thanks to the electronics. So we have had an increase in interim hearings and a slight decrease in final hearings, although as we're coming out of the lockdowns, the final hearings are going up again. Thanks.
Yeah, ours is similar. I mean, we've been doing electronic filing for many years now. So I think in the courts of appeals, the number of filings was really not affected very much at all. That will change, I think, because of the slowdown in certain types of proceedings in the district courts. But I think other than the criminal cases, which really slowed to a crawl, I think civil cases, after a short blip of fewer filings, I think sort of quickly resumed. I think it'll take a little longer to resolve cases now as a result of some of the limitations on hearings and witness and document review. But for the most part, I think civil cases have not been affected that much. But I agree with what Stephen said. Criminal cases have been greatly affected.
Thank you very much. In response to what strategies have been were parties that do not have access to internet facility, we still have physical hearing in Nigeria, but maintaining the COVID-19 protocols. Litigants file cases and it is disinfected. The papers are disinfected before it's circulated to the judges. And for people who do not have
NG, I think we've just lost the sound there. And I think.
Can you hear me? So parties we still have physical hearing in our court in Nigeria, but we maintain social distancing and observe all the COVID-19 protocol. We have disinfectant tunnels. We disinfect all the documents that are filed. And in the courtroom, witnesses are kept in boxes with screen. And before they come into the courtroom, they sanitize their hands. So for people who cannot afford that, we still have provision for physical hearing of our matters in Nigeria. Thank you.
NG, could I just make one point in response to one of your questions, which was how the legal profession has responded and whether we've been surprised in how they've responded. Firstly, COVID has, I think, seriously affected the work available to many, many lawyers in lots of different areas of work. There are a lot of lawyers who are doing no work and have no income or very, very little income during this period. A lot of people involved in civil cases, really there's very, very little going on for them. But I am very, very pleasantly surprised with the way in which the legal profession have embraced the idea of remote hearings in cases where they're possible, and they have got up to speed very, very quickly. And I suppose we shouldn't be surprised, because this is an opportunity for people actually to continue working in circumstances where otherwise they may not be able to do so.
I'd like to wrap the session up now and thank you all for participating in what I found a fascinating session. I also want to thank our co-sponsors, the IBA Access to Justice and Legal Aid Committee and the Forum for Barristers and Advocates. And lastly, we want to thank you, the viewers, for sharing your time with us in discussing these important issues. Thank you and goodbye.